Sorry. Hello everyone, welcome to our series on the Constitution of the India, and we will divide into the Article 13, a crucial provision that safeguard our fundamental right. So let's start it. Article 13, law inconsistent with or in derogation of the fundamental right. So what is a key component of the Article 13? Let's see. So what are the key components? Clause 1, all law in force in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent with the provision of this part, shall be extended to such inconsistency be void. That's mean clause 1 में बोला गया है कि all the law इन फोर्स ऑफ टेरिटरी ऑफ इंडिया की जो भी लॉ हैं और जो इंडियन टेरिटरी में एप्लीकेबल है इमीडिएटली बिफोर द कमिटमेंट ऑफ दिस कॉन्स्टिट्यूशन, इस कॉन्स्टिट्यूशन के कमिटमेंट से पहले, इन सो फॉर एज दे आर इनकंसिस्टेंट विद द प्रोविजन ऑफ दिस पार्ट, वो जितना पार्ट उसका इस कॉन्स्टिट्यूशन के साथ में, इन फंडामेंटल राइट के साथ में इनकंसिस्टेंट है, दैट पार्ट शैल बी एक्सटेंडेड टू बी इनकंसिस्टेंट एंड बी वॉइड. वो पार्ट खत्म हो जाएगा. Now let's see the clause 2. The state shall not make any law which take away or abridge the right conferred by this part, and any law made in contravention of this clause shall to extend the contravention be void. और अगर नोट like the state shall not make any law, स्टेट कोई ऐसा लॉ नहीं बनाएगा विल टेक अवे, जो कि ले लेते हैं एब्रीड द राइट कन्फर्म बाय दिस पार्ट, या इस पार्ट में जो राइट प्रोवाइड करे गए हैं उन राइट को इन्फ्रिंज करते हैं. अगर कोई ऐसा लॉ बनता है तो उस लॉ का वो पार्ट अपने आप ही वॉइड हो जाएगा. सो वॉइडिंग इनकंसिस्टेंट लॉ, लेट्स ब्रेक इट डाउन. The first clause make existing law void to the extent to their inconsistency with the fundamental right. This ensure that no pre-constitutional law can violate their rights. इसका मतलब ये था कि जो लॉ आपके प्री कॉन्स्टिट्यूशनल थी, कॉन्स्टिट्यूशन के बनने के पहले थे, एंड इफ दे आर इनकंसिस्टेंट और दे आर लाइक they are violate the fundamental right, these law will be void. So they ensure no pre-constitutional law violate these rights. Okay. And state limitations, the second clause is equally important. It's prohibited the state from making any law that take away or abridge fundamental right. Any such law would be deemed void to extend to the contravention. Okay. So impact and significant. What is the impact? So what's the impact of and significance of Article 13? Let's see. Protection of right. Article 13 act as a shield and protecting over fundamental right from both existing and future law. And second, judicial review. It's empower the judiciary to review the law and strike down those inconsistent with over cherished rights. Okay. Now Article 13 हम लोग देख लेते हैं. I mean there's some other thing as well. Now we go through the article, like Article 13 clause 3. In this article, unless the context otherwise required, law include any ordinance, order, bylaws, regulation, rules, notification, custom or uses having in the territory of India the force of law. Okay. And law in force include law passed or made by the legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in the particular areas. And clause 4, nothing in this article shall apply to any amendment to the constitution made under Article 368. Okay, this is the clause of Article 3. Now we see this inconsistency with the fundamental right, and like Article 13 declared that all law that are inconsistent with or in derogation of any of the fundamental right shall be void. In other words, it's expressly provided for the doctrine of judicial review, and the power has been conferred on the Supreme Court, Article 32, and the High Court, under Article 226 can declare a law unconstitutional and invalid on the ground of the contravention of any of the fundamental rights. Okay, now the word law is in Article 13 has been given wide connotation, so as to include the following: a permanent law enacted by the parliament or the state legislature; b temporary law like ordinance issued by the president of the state or government; c statutory instrument in the nature of declaration legislation, executive legislation like order, bylaws, rules, regulation, or notification; and fourth, non-legislative sources of law, that is custom or usage having enforcing law. So, the word law in Article 30 has been given a wide connotation. So I'm just going to discuss more thing about it. Like, thus not only the legislation, but any of the above can be challenged in the court as violating a fundamental right, and hence can be declared as a void. Further, Article 13 declared that the constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court held in the Keshavanand Bharati case 1973 that the constitutional amendment can be challenged on the ground that form part of the basic structure of the constitution and hence can be declared as a void. So, if there is a violation of the basic structure of the constitution in the case of Bharati court, given this its guideline, that can be challenged and declared to be void. Now, doctrine of eclipse, we are talking about it. The definition: the doctrine of eclipse is a legal concept that deals with the temporary enforceability of the law that is inconsistent with the constitution but later regain validity after constitutional amendment. In other words, if a law is inconsistent with the constitution, it is considered eclipse or render ineffective until it's brought back into the conformity with the constitution through the amendment. So if there is any law which is inconsistent, which is so that law can bring back with the, like, in other words, if a law is inconsistent with the constitution, it is considered eclipse or render ineffective until it brought back into the conformity with the constitution through the amendment. So we can make the do the amendment and bring that law back for the public, so that the part which is inconsistent would be removed from that law. So that is the doctrine of eclipse. And now we are discussing doctrine of severability. As mentioned earlier, the doctrine of severability pertain to whether a specific part or provision of a legal document, such as a contract, statute, and regulation, can be separated from the rest without affecting the overall validity of the remaining portion. It includes a severability clause that explicitly state that if one part is found to be invalid, it can be severed, and the remaining part will still be enforceable. That means, like, if there is any part of that law that is inconsistent, that part would be void and rest of the law will be enforceable. Okay, that's the doctrine of severability basically. So thanks for the watching this video. Thanks for joining us and understanding the essence of the Article 13. Stay tuned for the more insight into the Constitution of India. Don't forget to like, subscribe the channel. Until next time. So take care. Thank you.